it just doesn't get there. So I typically recommend, I don't recommend that my school districts get involved in litigation anymore. I've learned over time it really takes too long, and they're gonna, yes, it's a business, right? So I might make some money, but is that really the best way to do it? And maybe helping them think through a legislative strategy is a better way to do it. I know that's not realistic in some states.
Okay, I'm going to stay with you, Maureen, and to the subject of the Equal Education Opportunities Act, and using Alan's term, talking on behalf of children of limited English proficiency. If you could talk a little bit about the Horn versus Flores case and how that, sort of your views in terms of the case. As I mentioned before, you filed an amicus brief in that case, and what may have come out of that case that may or may not have changed the law.
Right. I mean, that's a mess, right? You had, not only is it's a mess in the courts because the Supreme Court obviously has a political point of view, and the district, Nogales, which has had some very good, and still continues to have, some very strong leadership from the board and the superintendent. At the same time that they're saying we need more money for our kids, they were making improvements. And so what did the state do? It turned around and punished them for making improvements. So they were doing good for kids, and then the state says, oh, well, obviously you don't need that money, which is just so perverse that you want to scream. So that's a problem, and I hope that the lower court is going to do something good in that case eventually. But in the meantime, I'm working with Tucson Unified, for example, and you can see the repercussions of that throughout the state about the limitations and the programs that they have to implement, and how the kids in those programs, because of the hours that they have to be in there and the prescription that they have to do, they miss being in electives and other programs and having opportunities to talk to kids that speak English, because of course that's one of the things, you want to have kids have as much interaction as possible. And yet they're they've got these restrictions, and there does appear to be some sort of waiver that you can do, but to do some more dual language. But of course the state, it's got its issues with how it handles. So I'm very pessimistic about Flores. I'm pessimistic about what's going to happen in Arizona on English language learner programs because of where the state is. I'm not pessimistic in the rest of the world. I'm just pessimistic in Arizona. I think.
Why are you not pessimistic about the rest of the world?
Because I think that school districts really want to do the right thing. They want to, at least the ones that I think we all work with, really want, and I do use the term English language learners, so forgive me, that they really do want to do the right thing for English language learner kids. And so we've seen some very good programs being developed and a real commitment in school districts to try to offer those programs. So where I don't see the state laws restricting, I see a lot of good things. In Illinois, is anyone here from Illinois? It's a state, as you probably know, that is, it highly regulates English language learner programs, but for the most part in a policy way that's good. I don't agree with everything they do, but they say, for example, if they're in a school, in a grade in the school, if 19 or more kids speak the same language, you have to offer a transitional bilingual education program, not an ESOL program. You have to offer a TBE program. Well, we can argue all day long about whether we think ESOL or TBE is better or worse, but that's what the state does, so people do it. I have a district that I represent that is able, under that law, to do a lot more dual language, and they're doing variations on the dual language. So they're not doing dual language that you all may typically think about, oh, they've got some schools where you do 50% primary English and 50% primary Spanish. They've got some of that, but they're doing a number of dual language different models because some of the white parents want them and they want some variations. And so at U46, which is Elgin, they're doing some amazing work there. They just got an award from the dual language group, whatever it's called, on their work. So I see from my work with school districts a lot of very good things going on out there to really help English language learner kids. And I think on the No Child Left Behind front, or ESEA, the fact that we have had to disaggregate that group has been very helpful and is very useful. So I'm hopeful about that. I do think we need more money to implement this. We've got issues about, do we have enough trained teachers? Because especially if you go to a TBE model in Spanish, you've got to be fluent. If you don't have any, if it's an ESOL model, it's a whole different piece, you know, in terms of background. But I do see it as being, I'm very positive about what I see out there with my districts. I see them doing very innovative bilingual special ed classes, you know, and so there's a lot of great work going on there. I see some very good programs going on for ELL kids who are gifted. And so I see a lot of really interesting models happening. I see some of the other folks at the other end table, oh, yeah, sure, what's she smoking? But at least the districts I represent, I see a lot of very good things happening.
All right, Alan, you got your chance.
I just threw out the bait, you know.
Okay, and I will bite it.
Good.
Massachusetts was the first state in the country to have a transitional bilingual education law enacted in 1971 and implemented in 1972. I, for one, litigated all over Massachusetts about the failure of these school districts to implement the statute as was outlined by the legislature, and won in any number of cases, at least a dozen cases that I filed with the Office for Civil Rights, 3 federal lawsuits that ended up in consent decrees. So we found that school districts were not implementing the law, they didn't like it, they didn't want it, and they resisted it, and even when there was a court order, they resisted it. The one federal case where the superintendent really wanted to implement it was Worcester. So back in 2007, I did a study with Northeastern University School of Law that looked at the consent decree, because at the time we got the consent decree in the early 80s, the only other language was Spanish, but by the time 2007 rolled around, there were many other languages, but the consent decree only applied to Spanish. So we did a study comparing how the kids in the Spanish consent decree program were doing compared with kids who were not in the consent decree program because they were in other languages, and the kids in the consent decree program were doing much better. So it can work. But what happened was, in 2002, along came Ron Unz, who was first started in California, moved on to Arizona, and then came to Massachusetts, and with an initiative that calls for immersion. And it eliminated transitional bilingual education. It was put on the ballot, and 67% of the people voted to do away with transitional bilingual education. However, when you look at the communities where the kids lived who were benefiting from transitional bilingual education, they voted against it by well over 90%, closer to 95%. So what we have now is something called structured English immersion, and all you need to do is take a look at the test scores that the state does now with No Child Left Behind and all the other testing that it does under what's known as MCAS, Massachusetts Comprehensive Assessment System. And you'll see that the kids of limited English proficiency are doing the worst. Worse than that, they're dropping out. Those who are there to take the test are doing terribly. The others drop out. One little factoid I'll give you from the school finance case that relates to this. In Springfield, they administered what is called a Peabody Picture Book Test for kids who are just starting out in school. They haven't had any instruction of anything. They're kindergartners. And the kids from Springfield, particularly the limited English proficient students, were scoring between a year and a half below the national norm. In other words, everybody, if you say they start out the norm, these kids are starting out worse than them. There's no, of all the 1,000 exhibits and 114 witnesses, I can summarize all the facts like this. These kids who are starting out below never get any resources to catch up. By the time they're in the 5th grade, they know they're not going to succeed in school. Those who do start high school, over half don't finish, and 67% of people in prisons don't have a high school diploma. Connect the dots. That's what happens, that's what's happening here. Someday in the future, I hope I'm around for it. I think we're going to have a program that teaches kids in a language that's comprehensible to them, while at the same time they learn English. It'll never be called bilingual education, but whatever they call it, it's got to come back, because the teachers who are in the classrooms, they don't know how to teach these kids. Presumably, the state is requiring them to learn the skills to do that, but if they were doing that, if the state was doing that, which they're not, these kids might succeed, but they're not.
Can I just jump in? If that's
Absolutely.
okay? And I just want to ask, let's take your example that you just gave and say, is there any type of federal law that serves as, forget about the Constitution for a moment, is there any federal law that you could potentially use to litigate this? And then question 2 is, using Maria's example, is there a strategic approach to deal with what you have just presented as a, you know, if you can collect that data and present it, is how do you get at it? I mean, it's overwhelming, but I think we're here to hear suggestions from an expert panel about confronting that in either approach.
We have filed, I now do a lot of volunteer work for the Multicultural Education Training and Advocacy Group, which is a national organization dedicated to improving education of limited English proficient children. And we filed a number of cases with the Office for Civil Rights, things that are pending in Washington at the Department of Justice, over the Boston Public Schools. So that's one approach. The approach that I think, if you wanted to take the real approach, the hit a home run approach, if you could get the resources to do this, assuming Castaneda is still good law,
It is.
and it is until they say it
Right.
requires intent,
Right.
then you have to show that here they've chosen this theory, structured English immersion. They haven't put the resources that they say is necessary under the theory, and then the results speak for themselves. Court, give us an order to do something different. I mean, I keep saying to my colleague, Roger Rice, we need to do this, we need to do this, we need to do this. And the problem is, how long do you need before you can have the kind of data that you need? How long should this experiment be given a chance? And that's the problem. The real answer, at least in Massachusetts, is two-way schools work. There's several of them around, and they do work. Kids are doing much better. In fact, in one in Boston, it worked so well, they've now approved a high school.
Wow.
And it's going to be wonderful because it's been proven that these programs work. All the others aren't working. Even TBE was remedial. It was just until you learn enough English to succeed, but it wasn't really saying we ought to be able to learn in languages more than just English. In the rest of the world, you can go to Europe and people are fluent in 5, 6 languages, and it's no big deal. And they've implemented these programs around the world, and they work.
Just play off of that, just to actually pick up on a thematic. I thought I was going to lean more toward this side of the table than this side of the table when you started, but maybe I'm on balance. Because I sort of do share Marie's optimism, and so I'm going to pick up on that theme. But then you've come back to it, which is there's a common thematic we've all heard. It's data, and the transparency and the light on data. And the stories that I will not tell you, but that I could, that have literally, where NCOB simply, for all its flaws, and there are many, because of what it required in terms of disaggregation, changed the conversation systemically overnight for states and school districts. One side note, when I was at OCR and we were launching a statewide compliance review on issues of LEP compliance, we went in to discover the state actually had no disaggregated data, so we had no basis on which to even begin the first step of the Title VI investigation was to require, start